What's up, guys? Welcome back to Kitchen Court Cases, where we
What's up,
watch court
guys?
and welcome back
Nope,
to
didn't
Kitchen
manage
Court
to do that.
Cases, where we
What's up,
watch court
guys?
and welcome back
Nope,
to.
almost had it. I swore I had it paused. That's okay. We figured it now.
Hi, Karen. Hi, Courtney, Zysifer, Grammy Rita, Vicky, Kitchen Court Cases, Courtney, Vicky. I hope you guys are all well. Thank you for. No, you're not tripping. That was my fault. Sashina, Karen, sorry if I didn't say it properly. If only I could do sound effects when I wanted to. Wouldn't that be glorious? I hope you guys are doing well today. Many of you probably just saw. Hi, Trish. How's COVID, honey? Are you feeling better? Um, Good time for a med check. Take your meds, clock in for your shift by hitting the like button, guys, please. It really helps me with YouTube Daddy. I posted a new video just recently that you might have seen with Judge Webster, but I have for us tonight a very interesting live, well, not live, TPO. It's live because I'm live and you're live, but I'm glad to hear that you're doing better, Trish. That is excellent to hear, guys. Please let me know what you had for dinner. If you didn't like what you had for dinner, tell me what you wish you had for dinner. As you can see where I live in Canada, it is still bright and sunny out. The lighting still favors me. Thank you, lighting gods. Beavers, Canadian beavers, exactly. So, meatloaf and fried potatoes from Vicky MB. Glad to see you here. Tanya's here. Excellent, excellent, excellent. Um, I haven't had dinner yet. I'm not hungry yet, to be totally honest with you. That's the way we do. Trish had pot roast with baby potatoes and carrots, French bread. Rita wishes she had lobster and a baked potato. That does sound yummy. But you had ice cream. That sounds pretty good too. Courtney had chicken tenders, salad, chopping up a melon for dessert. Don't even say melon over here. You know the danger of that, Courtney. I'm just joking. Um, Okay, we're gonna start with a clip before we get into our TPO. Sashina had a chicken burrito and homemade guacamole. I love it. Um, I don't have other channels set up yet, Courtney. I need to get backup channels set up before I get in YouTube Daddy's bad graces. Ah, Cellulite Yoga Pants said I had fajitas at a Mexican restaurant, so it was yummy. Excellent. Oh, Sashina, her food tasted like food. Round of applause for food tasting like food. I was like, should I admit what binge I'm on lately? I'm on a binge. You know, I binge different foods. And I'm on a binge right now. For weird. It's weird. It's all my neurodivergent people understand. So, we're gonna watch this one first, and then we're gonna watch the TPO hearing. Hi, Charles. Hope you're doing well, friend. Welcome, welcome, welcome. Oh, it's right now. It's a specific Subway sandwich with like a lot of pickles on them. No meat, just veggie. All dressed chips inside. It's weird. It hails back to my childhood, I think, when I wanted Subway all the time. I was not able to get it very often. Um, I understand, Sashina. Okay, sorry, somebody just said pepperoni pizza. Zysifer said pepperoni pizza made in a cast iron pan over a campfire. Wow, make a video about that. That'll get 1 million views. Chris just ate dry frosted mini wheats for a snack. Almost choked to death. You were desperate. Okay. I recommend I recommend Rice Krispies dry better. Um, Jay is here. Welcome, Jay. Can you guys please make sure you've clocked in for your shift? We need to talk about cereal one day. Our next brunch, actually, let's talk about cereal because cereal in Canada is different than cereal in the United States, although they call it the same thing. So there's a whole set of lies that's being told to people that we need to get to the bottom of. Um, Courtney, you eat the same thing almost every night until you get sick of it and move on. That's what I mean when I say I'm on a binge. I will eat this Subway sandwich, the specific one, for however many days until I am done with that. And then I will move on to another item. And that's the way I do. Um, that's just part of my ADHD. We don't really know what the diagnosis is. What else was on the agenda today? It's July, guys. Please don't forget about Christmas in July. If you'd like to send a Christmas card, I would love to receive it and put it up. I've got the P.O. box information down below. Um, what else? I don't even know. Charles is going to Fulton County. Be careful, Charles. You know how Judge Manning gets in Fulton County. What a good reminder to just start watching some court. Court is what I love. It soothes me to sleep and it wakes me in the morning. Oh, Captain Crunch sucks, Jay? Are you telling me there's a difference between Captain Crunch in Canada and the United States? Reach. Um, so this is an older one, but I was listening to this while working on other stuff, and then something popped up that you guys are going to hear, and we need to figure it out together. I didn't even investigate. I just said, let's watch this together and then we'll investigate together. Okay. Yeah. Be a dick. Give the like a click. Tell me what strain you're smoking, all the usual stuff. Turn on the video, dumbass.
I believe the person who's appearing from that jail is Miss Shaw's client. Miss Shaw's not here, so.
All right. Mr. Kim, sorry. Who are you ready? Are you ready with, who are you ready with?
Mr. Grenier and Ms. Lafave.
All right, let's start with Mr. Grenier then this morning. Good morning.
Can I take this as well?
Oh, yes, I'm sorry.
Just wait, it gets weird.
All right, people of the state of Michigan versus Eric Mark Grenier, 226897 ST. Mr. Grenier appears here in person along with his counsel, Mr. Kivasari. The prosecution is here through Assistant Prosecutor Carl Downey. We were set for a continued jury trial date. How are you progressing in this matter then, Mr. Kivasari?
Well, Your Honor, I filed a motion to suppress evidence that's been noticed for hearing on July 7th. And I would be seeking to file a brief in support of that motion today. And we'll serve that on the prosecutor's office. I would just be asking the court to table the trial date pending the resolution or the outcome of the hearing on that motion.
All right.
Your Honor,
Yes.
that's the first I've heard of a note or a hearing date. I don't have, all I got was a blank notice of hearing.
Okay. I just listened to this and I remember and I just saved it on my desktop. I didn't even touch it again. Once I heard the weird noise, which is coming up in like 6 minutes, okay? I hadn't been looking at this. What the fuck? He just looked like he was stripping. Oh my God. Also, I spilled something. Anyways, let's.
File here, so.
Yeah, Your Honor, that's what I have as well. I believe I may have received an email from the court clerk here providing me with notice of hearing that you had signed, but I don't, for whatever reason, I don't have that in my file either.
Well, it's your responsibility. She gives you the date, your responsibility to notice it's a hearing.
Yes, Your Honor, I'll make sure that that's in this
Your Honor,
file.
that's what, the end of next week.
I know.
And we're just now getting notice.
And he hasn't filed his brief in support yet. So and this has been pending, and this is a traffic matter, so we're gonna push it all back. Is that all right with you?
Yes, Your Honor.
Mr. Grenier, do you have a problem with that?
No, Your Honor.
How about you, Mr. Downey?
No.
All right, let's get some realistic dates and times and cutoffs while we're here. Yes, Mr. Grenier, thank you. All right. All right, so, when are you gonna have your brief filed realistically?
Well, I was going to try today, Your Honor, but if I'm given a little extra time, I'll put a little additional work into it.
All right, how about your brief is due, and I'm gonna write this down. Your brief is due by the end of next week, the 7th. All right,
Yes.
Mr. Downing, how long do you want for responsive? 2 weeks?
Beyond that, yes,
All right, 3 weeks.
2 weeks, I think is, well, probably 3. I mean,
I know you're down staff over there. I know that. So that's why I'm asking. What do you need? 3 weeks, okay?
I think 3 weeks would be sufficient.
All right. So July 28th, responsive pleadings. Make sure you send the judge a courtesy copy. Court rules require that. All right, so we're gonna look for a hearing date on the motion, and we'll just trail the jury trial behind it, but we'll get a motion hearing date sometime. It is going to be, let's see, I would say probably, do we have anything around like the 10th or the 16th or the 17th? I know we got a 2-day, we have a,
Of August,
yes.
August 11th would be good.
At what time?
We could do, the afternoon is entirely open.
How about 1:30 on August 11th? For the motion hearing date.
Should work.
All right, let's set, are we taking testimony at this hearing?
I would assume we would have the officer testify, Your Honor.
All right, so, let's not set anything. We'll set a couple of hours aside for this, and if we get in custodies, I think we should probably make this our afternoon docket that day.
Your Honor,
So if something changes, let us know, because we're holding this open for you.
yes, Your Honor. What was the time on August 11th?
1:30.
Okay, I do have a pretrial conference at 1 that day, but it should be brief and probably by phone,
All right,
so.
so you heard that loud and clear. We're holding that open for you. If something changes, I need that time back from you.
Okay,
All right?
yes, Your Honor.
All right, so that was August 11th at 1:30. We got it set for the balance of the afternoon. We'll hear testimony. All right. Anything else this morning we can do on this file then?
Did you want to set a trial date?
I'm just gonna trail the trial with the motion date on August 11th at 1:30. So we'll see what we're doing then when we hear the hearing and we go from there, okay? So that'll be a motion and jury trial. All right. All right, gentlemen, have a good day. Thank you. Your bond continues in place. Any questions, Mr. Grenier?
No.
All right, thank you. Oh, she'll give you your date and writing. Is Ms. Schaub here yet? No. We're waiting for your lawyer. We'll be with you as soon as we can. Are you Mr. Is it Zettner?
Yep, Zettner.
Okay, we'll be with you shortly.
Okay.
Where is Ms. Schaub? All right, and Mr. Kivisari will do your other client. Ms. Lafave, if you want to come forward, please. We mute that a little bit.
Your Honor, if I may, I'm gonna grab my laptop from the back of the courtroom.
All right. All right, people of the state of Michigan versus Tiffany Louise Lafave, 237361 SM. Ms. Lafave appears here in person along with her attorney, David Kivisari. The people are here through Assistant Prosecutor Carl Downing. We're set today for a jury trial. Mr. Kivisari, how are we coming along?
Your Honor, I've got a disc with discovery materials on it, lots of photographs and video and lots of Walmart video. And I'm having trouble accessing what Mr. Saminsky saw to be some footage of the actual parties involved in this altercation. He had told Ms. Richards that he didn't find the video helpful because the altercation itself did not appear on the video, but some sort of pursuit apparently did. So I'm having trouble finding that and actually viewing it, and I would certainly want to take a look at what the prosecutor found unhelpful to see whether it is helpful to my client. So I'm rifling through these files on the disk, and I can't for the life of me find what Alex must have seen. There's a lot of photographs from security cam that are entirely irrelevant. They simply show parts of Walmart that were not involved whatsoever.
How many hours are we looking at of video footage? Or is there an hour or more?
It's hard for me to tell, Your Honor, because of the way that the files are listed. I'm not even sure what's video and what's not. I see very clearly body cam footage, and I've been able to view that, but that's interviews after the fact. What I'm really trying to find here is what Mr. Saminsky saw.
So I know Mr. Saminsky has now resigned from the office. Mr. Downing is only here as a relief pitcher, right, Mr. Downing?
That's correct.
So, do we have somebody that's assigned on the case from the office at this point, Mr. Downing, or is there a way? Are we?
Probably be Ms. Cass.
Have you tried calling Ms. Cass?
I've spoken with Ms. Richards directly about the issue, and Ms. Lafave has a probation violation hearing coming up as well in the circuit court later this morning. So I'll be letting Judge Nina Mio know the same thing, that I'd rather address the underlying facts here before moving to any sort of a guilty plea.
Well, have you asked Ms. Richards, or have you discussed the issue of whether or not she is still able to contact Mr. Saminsky about outstanding questions, or has she tried looking for the video footage herself? Or
I'm not sure that she has, Your Honor. She simply forwarded along a statement from Alex, which was the reasoning behind his deciding to charge.
well, do you have email access to Mr. Saminsky?
Not that I no.
I mean, maybe he can tell you about where to look for it. Somebody's gonna have to ask him.
Okay, I'll try to contact him, Your Honor. And
So,
maybe he can help me sort through all these.
yeah, so yeah.
Okay.
So in the meantime, I'll give you a new trial date, but you got to get that moving
Sure.
one way or another. And then we'll get a firm date on if we need to here at the next pretrial, at the next jury trial date. It'll be another Friday
Sure.
general call date. And if we're heading towards a trial, then I'll get you a firm date, but I want to know where you're going, which means you got to figure out your discovery to figure out where you're going.
Yes, Your Honor.
And down we go. So let's say, what are we in here? 1st of July. I'll give you another month-ish.
Yes, Your Honor. That should be more than sufficient.
All right.
We can go Friday, August 11th again.
Does that work for you, Mr. Kivisari, 9 a.m.?
Well, Your Honor, that is the day I have that pretrial conference, but that's not till the afternoon. So yeah, that should work as a roll call, or as a
Yeah, that's
status
just
call.
at 9 o'clock a.m.
Okay.
But yeah, all right. So try to get all that figured out between now and then.
Yes, sir.
All right, then in the meantime, your bond terms remain in place. Ms. Lafave, do you have any questions?
No, Your Honor.
How about you, Mr. Downing? Anything you want to set forth today on the record?
No, I don't believe so, Your Honor.
All right, thank you. Have a good day.
Thank you.
Wait, this gets weird. Hi, guys.
All right, here we go. Could you try calling Miss Sham? Does she like?
I just sent Sue a message and Sue's gonna try to call her.
All right. All right, Mr. Good morning. I mean, have a good weekend. Happy 4th of July. Mr. Percola, where do you want to go now? Which client? All right, Mr. Cayman, if you could come forward, please.
Okay, it might be this part. I'm telling you, I was like, I'm not kidding. The noise we have to figure out. I can't scrub through it to find it. Lisa, you're hilarious. Nobody needs a pole. You don't need a pole. Mm-mm. You can dance without it. And of course, no, this shirt doesn't, or this dress doesn't help with cleavage at all.
Well,
People of the State of Michigan versus Sean Charles Cayman, 227126 SM and 237456 SM. Concerning the matter, then, Mr. Cayman is present here in court along with his attorney, Robert Percola. The prosecution appears through Assistant Prosecutor Carl Downing. We're set for a sentencing in one file, and it looks like a plea in the more recent file. Counsel, what is the status, please, this morning?
Yes, we do have a resolution of the outstanding matters set for sentencing. We put those on the record.
All right, if you would, please.
I can state the terms, Your Honor. In exchange for Mr. Cayman agreeing and accepting that the people are no longer recommending a non-jail or no objection to treatment of disposal abuse act. And in fact, we will now place an objection to that type of treatment for 22-7126 M set for sentencing. And if Mr. King enters a plea to the bond violation for having contact with Ms. Cotton, then the people will dismiss the file 23-7456-SM.
Okay, so as I understand it, before there was a recommendation for a non-jail sentence, there was a dismissal for the bond violation and no objection to treatment under the spousal deferred sentencing scheme. So now, as I understand it, then is it still going to be a no contest plea?
He's, I believe, already entered a plea.
Oh, I'm sorry, he has, that's right.
Except he needs to enter a plea to the bond.
Dave, thank you so much. I love it. You're right. I did drop some right here. Oh, was it over there? It should pop up in a moment. Thank you so much. I appreciate that. You guys are great. We're going to have a great time tonight. We have a lot of court to watch, so don't even think about turning away. seriously, the noise is coming. I'm not giving up. It fucking happened. We'll listen to it and then we'll get on to the TPO. Oh, Dave. You're so sweet.
Bond violation.
But I want to go back through it if the recommendations and the terms are changing, I want to go back over that with them. So now the recommendation is, there's no prosecutorial recommendation for a non-jail outcome. That's taken off the table.
Right.
And they're going to be objecting to any requests from the defense for treatment under the Spousal Abuse Act.
Right.
That's correct, Your Honor.
But that's still free to argue by the defense.
Well, yeah,
I
it's
would
just subject to
assume
the
so,
objection.
Yes.
And the people wouldn't be objecting to our continued request for a non-jail outcome.
No, we're not placing any kind of recommendation or no objection on the record. In other words, we're free to argue for jail.
Well, that's not how I understand it, I guess.
It was simply a no objection. It was, we're no longer recommending non-jail. There's no replacement with a no objection for non-jail.
You need some time?
This comes down to just how these interplay with each other. If the prosecution is not recommending non-jail and they are not indicating an intention to object, then whether they're specifically stating they're not objecting or not is relevant to the fact that they're not going to object.
No, I don't see that.
How many here understood that? Anybody? No.
Because,
Don't
Judge,
even ask me.
the reason that I'm saying that is because when they say that they have
Let's go ahead and listen to that back again.
whether they're specifically stating they're not objecting or not is relevant to the fact that they're not going to object.
No, I don't see that.
How many here understood that? Anybody? No.
Because,
Don't
Judge,
even ask me.
the reason that I'm saying that is because when they say that they have they're withdrawing the no objection to the deferral and specifically state that they will now object, as the purpose of the offer is to maintain a DV conviction. So that's the stated purpose. There is no, if they wanted to state that.
Why is nobody asking any questions about this situation? This is crazy. You can understand why, while listening to regular court, that one popped out at me and I was like, boom. Just like pull that window over there. I didn't even download it. I just left it open. Ridiculous. Let's just finish this off. I didn't even finish listening to it. We'll just finish listening to this defendant, I guess. And then we'll continue on. Guys, if you're just getting here, welcome. This is Kitchen Court Cases. We watch court in my kitchen. Please help yourself to a drink or a smoke or whatever you'd like for tonight. Tell us in the chat what you're having. If you had dinner, tell us what you had for dinner. If you didn't like it, tell us what you wish you had. And ask any questions you might have. We're weird court nerds. So get ready for that.
They're continuing to object to a non-jail sentence, presumably they would have put it in there because they put it in for the other term. That's my point, Your Honor.
Well, I don't see that that is necessarily.
And that's how I read it.
Coming from that statement.
Well, okay, so I'm not sure, but this is what I understand as it all sits on your table with the bowl of chili that's been spilling all over the edges here. In regard to the matter, Mr. Downing's telling me that he feels under the terms that they have agreed to, that if they want to get up and argue for jail under the agreement, that they're free to do that. They're not saying that they're not saying that they don't object to a non-jail out sentence. You're arguing that, okay, they've turned the plea around and said they're no longer recommending a non-jail alternative, but they're saying that they're not objecting to the defense request for a non-jail alternative. But he's saying he's not objecting because he might go ahead and argue for it. So it's really semantics in my mind.
Well, it's by implication. I'm going from experience in these situations, which suggests that at the time of sentencing, the prosecution will not be attending and will not be voicing any objections. I don't have any reason to believe, based on our discussions and the terms as written of this plea offer, that they would intend to do that. So I mean, it's not explicit. I thought it was implicit within the context. Obviously, since we're arguing about it, it's not as clear as it could be.
Dave has made an excellent point. I should be patted down for safety. Thank you, Dave. Thank you for paying for that pat down. You know, in Canada, a toonie, that'll get you a pat down. This is in Michigan, folks. Look, I gotta pull that down a little bit. No, not those. Guys, this is Michigan. Like I said, don't be a dick. Please go ahead, give that like a click while you're here. It helps me a lot with YouTube Daddy, a free way that you can help me out. We are in Dickinson District Court.
That was my understanding of it. I don't know that it necessarily will change anything today, but
this offer was extended by Ms. Cass. If you want to have him do this over in a week when she is available to clarify what she wants done, but sentencing on file 20 on the 22 charge is set for today.
let me propose this, Your Honor, if I can just take a moment to think to the next step. I don't know that there is any material change, whether it's, if the prosecution comes to sentencing and makes an objection, and if the court, gives a jail sentence, even if it was a recommendation or a formal part of the offer that it was no objection, it wouldn't trigger any right for Mr. Cayman to withdraw his plea at that point. So I don't know that it has any material effect on the outcome, depending on what Your Honor wants to do with the sentence. So I don't know that it's something that needs to be clarified that far. I would say if the prosecution wants to come to sentencing and lodge an objection, then we can just argue about whether jail is appropriate or not at that time. But I don't think it would affect our ability to proceed with the plea at this time, just because it doesn't have that material effect. Like if we were arguing about a recommendation, I would probably hesitate more.
Your Honor, I'm not going to pound the table for jail, but he does have a record, albeit it's a little old. And it's a fairly lengthy one, mostly from the 90s into the early 2000s. So it's difficult for me to sit here and say we don't object to any jail, considering all that's transpired with regard to these matters. I am going to object to a deferral on this, in as much as we've now had a second charge of domestic violence that we're going to dismiss. I guess that's where we're at, and he's also going to be pleading to a bond violation.
Yeah, and that second part about the objection to the deferral is explicit and understood.
All right, well, in regard to the matter, like I said, I think it's semantics. Essentially, there's no recommendation. Sentencing is up to the court discretion of the court. So let's try stating the terms for the record again.
All right, so just after all that, In exchange for Mr. Cayman agreeing and accepting that the people are no longer recommending a non-jail sentence and no longer not objecting to treatment under the Spousal Abuse Act, and understanding that the people plan now to formally object to treatment under the Spousal Abuse Act. In the sentencing in file 22-7126-SM, and in exchange for Mr. Cayman pleading guilty to the bond violation, the June 4th, 2023 bond violation for having contact with the alleged victims, the people will dismiss 23-7456-SM.
All right, does that fairly state the terms, Mr. Downey?
Yes, and just to be clear, the charge we're dismissing is a domestic violence charge.
I'm aware of that.
If there are any other charges arising out of any of these incidents that are still under investigation, this plea agreement does not affect any of that.
And we understand that as well, Your Honor.
All right, can you get me a bond violation advice of rights, please?
A which?
Huh?
A which?
Bond violation? Is he pleading to the bond violation today?
Yes.
Did you do, I have a general advice of rights form, but there's a bond violation advice of rights form back there. Could you do one of those with him, please?
Not aware of a bond violation advice of rights form existing, Your Honor.
This is a weird court. Oh my gosh.
All right, in regard to a clean record on, I'll give you a minute to go over that with your client too. But in respect to a clean record on the domestic violence charge in the 22 file, do you think perhaps he should move to withdraw his plea and then we'll start over from square one? With the terms on the record, or with the old plea on there, he's ready for sentencing, but I feel like he needs to plead over because the terms have all changed.
Well, I think it can be done through the course of this plea. I don't know that he necessarily needs to withdraw it in order to be advised and kind of reaffirm it if he knows that if he's not willing to reaffirm it, the court would allow him to withdraw it.
So you're not seeking to officially withdraw the plea at this point. What's your opinion?
As long as the defendant is fine with proceeding with the terms of, or I mean, the elements that he put on the record to satisfy the plea on the original domestic violence, and he reaffirms that plea, I don't think we need to go through having him put those elements back on the record.
All right, you're all right with that then, Mr. Percola?
Yes, Your Honor.
All right, thank you. All right, Mr. Cayman, good morning. What's your full legal name, please?
Sean Charles Cayman.
All right, Mr. Cayman, I'm going to give you a minute to go over the form with your client and with your lawyer regarding bond violation. But a bond violation and a jury trial have a lot in common in respect to the matter that it's an open court type of hearing where you can use all of your powers that the court gives you to like bring in witnesses and evidence, use the subpoena powers of the court. All of those rights that you went over in this advice of rights form are basically the same. The difference being a bond violation is a hearing that's like in front of a judge as opposed to a jury.
Right.
Okay, so why don't you take a minute, go over that with your lawyer, and then we'll go on the record. I mean, we'll finish here.
The court's desire to have bond violation, this is a form that the court has created for itself.
Yeah, we've been using them for, I don't know how you haven't. We've been using them for, I don't know, a year at least.
I've never used one that I can recall.
Yeah.
Jess was with us.
Since, huh?
Jess was with us. I think she created it.
Just from across the way. Yeah, it's been
Do
a
you
while.
want to have both filled out in a bond violation then as well, since this is?
I'll take the new advice of rights as well, since we're going to reaffirm the plea. But either way, it's fine. If you want.
This is such a weird court. So hi, Mighty. Hope you're doing well. Ready to break out of tube jail soon, we hope. I don't think they would leave the piercings in when they booked him in jail. Do you think? I don't know. That's a good question. I use Streamlabs. I don't know. Whatever that uses. Seriously, what was that weird? I think they have to be removed too, Courtney. So I don't think that if we were seeing him that he would have anything in his nip piercings if they were pierced. Which reminds me of when I got my tongue pierced. I laughed about that story today. That's a funny part.
And thank you. All right, then, Mr. Cayman, in respect to the matter, did you understand the terms of the agreement as they've been laid out over and over on the record this morning?
Yes, Your Honor.
All right, so when you were here earlier, you entered a plea on the domestic violence in the 22 file. And we went over your trial rights and we went over the rights that you're giving up by pleading guilty. Do you remember? Let's see, it was a no contest plea, as I recall. Is that right, Mr. Perkle?
I believe it was, Your Honor.
All right. So do you remember going through that dissertation with me?
Yes, I do, Your Honor.
All right. So now you've entered a plea of no contest. You are set for sentencing. Then this new case of domestic violence came up here that's also on the docket for this morning, which resulted in a bond violation in the older case that you had entered a plea on. Because it happened right before your sentencing date that we were originally set on, as I recall. Is that right?
Like 4 days.
All right. So as I understand the agreement now, it has changed in regard to both the underlying as well as a bond violation on this older file. So I'm going to go over with you your rights that you have again. Okay. So your bond, like I said, there's a lot of similarities between your bond violation hearing rights and a jury trial or a bench trial. So I'm going to go over both of them again with you because if there's anything that jogs your mind that you don't want to agree with concerning the underlying charge now of domestic violence, as the terms have changed, that you told me that you know understand how the terms have changed. If there's anything that you don't want to do anymore in regard to the domestic violence or the bond violation, then we'll stop and we'll figure out how you want to proceed. Okay? All right, so you understand in regard to this domestic violence charge that you have the absolute right to have a jury trial, and in some instances you have a right to a trial by court. Are you aware of that?
Yes, I am.
In regard to the bond violation, you have the right to an open court hearing in front of a judge. Do you understand that?
Yes, I do.
In respect to both of the matters, you have the right to use all of the powers of the court that are indicated in these forms to bring into court any witnesses or evidence or to testify yourself. Do you understand all of the rights that are laid out in these forms?
Yes, I do.
And you've had an adequate opportunity to go over each of the forms with your lawyer? All right, then. In respect to the matter of the domestic violence, I went over last time with you the maximum penalties and the potential collateral consequences. Remember the collateral consequences, those things like if you're not a citizen, it could result in deportation. Those types of things are called collateral consequences. Do you remember all of
I
that?
do remember.
All right. In respect to the bond violation, then, I'm going to go over with you the maximum possible penalty and the nature of the allegation. In fact, yeah, Mr. Cayman signed a bond violation arraignment, a waiver form on June 5th. So anyway, but the motion in order to show cause indicates that you were arrested for domestic violence and had contact with Ms. Cotton on June 4th of 2023. contrary to the terms of your bond that this court laid out for you on October 7th of 2022. The maximum penalty you face on conviction is up to 93 days in jail and or up to a $7,500 fine. Do you understand the nature of that charge and the maximum penalty?
I do, Your Honor.
To the charge of violating your bond, then what is your plea?
Guilty.
All right, in respect to the matter of the domestic violence, are you wishing to withdraw your plea or reaffirm your plea?
Reaffirm my plea.
All right, concerning the matters then, do you understand by entering a plea of guilty and reaffirming your no contest plea, you're giving up your right to exercise each of the hearing and trial rights listed in the forms that you signed this morning?
I do, Your Honor.
And do you understand the court is free to impose any sentence that the court feels is appropriate up to the maximum provided by law concerning each matter?
I do, Your Honor.
All right, then, Mr. Cayman, understanding that and everything else that we've gone over here this morning, does it remain your intention to plead guilty to the bond violation and reaffirm your plea of no contest to the domestic violence?
It does, Your Honor.
Has anybody promised you any, are you on probation to, or parole to any other court?
No, I'm not, Your Honor.
Has anybody promised you anything outside of the terms placed on the record today in order to get you to plead guilty to the bond violation and reaffirm your plea of no contest on the domestic violence?
No, Your Honor.
Has anybody threatened or coerced you or forced you in any way to enter those pleas?
No.
Anybody tell you the courts would simply be more lenient with you if you entered pleas?
No, Your Honor.
Are you pleading guilty?
Have we ever heard that before? Tupac, you're back. Welcome back, friend. I hope that you're okay. You need to be punished with a paddle. Well, you know you've come to the right place. I can definitely hook you up with that. Oh my goodness. Welcome back. Also, Dave, thank you again for your super chats. Everybody, welcome. Please don't talk about Buddy's nipples. He's really sensitive about them. Okay? He's like covering them up.
In reaffirming your no contest plea freely, voluntarily, and understandingly?
Yes, I am, Your Honor.
All right, then, concerning the bond violation, Mr. Cayman, in your own words, how did you violate your bond?
I had contact with the victim.
All right, and you knew it was a court order under your bond that you were not supposed to have contact with her?
Yes, I did.
All right, and was there also some kind of a physical altercation when you had
No, Your
contact?
Honor, the agreement is to enter a plea for contact with Ms. Cotton only.
Is that right, Mr. Downey?
That's the agreement, Your Honor.
All right. All right, then, I think he's made out a sufficient factual basis based on that. Are you satisfied, Mr. Downing?
Yes, Your Honor.
Are you, Mr. Percola?
I am, Your Honor. Although maybe we could say the date of it.
Yes, I did on the allegation, but if you could tell me that was June 4th, you said it was, is that right?
That's correct.
Of this year?
Yes, I was, Your Honor.
All right, then, in regard to the matter, I'm satisfied that Mr. Cayman has made out the elements of the bond violation. I'm satisfied that he's reaffirmed his plea on the domestic violence after being fully informed of all of the changes. He has done so freely, voluntarily, and understandingly. I will accept the guilty plea on the bond violation and the reaffirmance of the no contest plea on the underlying. We'll set both matters over for sentencing. You'll go down to probation. They're going to update your recommendation. August 10th, 9 a.m. Unless you want to try to get that done, Mr. Percola, BB. All right, unless you want to try to get that done, BB.
Your Honor, do you wish
It was
to
a spot.
combine that with the sentencing on the 22/7?
That's what I'm getting at. So Mr. Percola is going to be out for some time. There's already a report done. They would just have to update it, but I don't know when if that's possible or not.
Know if the court wished to proceed.
Mr. Perkle, you are here on the morning of July 6th.
Yeah, the court has assigned you.
Well, I guess Let's call probation and see.
That's just a week.
I know. Or could you mix it in?
We're not calling probation. If somebody wants the rest of that video, go ahead and let me know. Hit exclamation mark email and I'll send it to you. What we're gonna do is close the curtain for 1 second while I go ahead and get our next thing going. Guys, thank you so much for being here. Georgia Peach, who else is here? Oh, Credence and Mikey, of course, almost out of YouTube jail. I hope it's not contagious. I'm sure it's not. That was creepy. Oh, Tupac, you're here. Welcome, welcome. Please be feeling better. I'm glad to hear that insurance is paying for something. We are you guys, here's what we're going to do. We are going to watch a bit of a case and then a case, okay? They're in Thurston County and the lady is a little bit intense. Let's just start with that. But what is the name for this judge? I don't know yet. And we sort of need to know his name because
All right, be seated, please. Morning. Good morning, everybody. Going to get started here on your cases. We are now on the record. Okay, so this is the Thurston County District Court Protection Order and Anti-harassment Order calendar. I'm going to find out first who's present so that I know which cases and in what order I'm going to handle them. So I'm going to look at the screens for your names. If I don't see them, I'll call your names. And if you hear your name, just ring out that you're here and I'll make a note that you're present. And let me start with Carmen Matias. Okay. Do we have Carmen Matias
he's going
present?
ahead and doing his, hold on. While he's going ahead and doing, said shut up. While he's in attendance, we'll also do attendance. Please go ahead and clock in for your shift. Big head contest. Right. Yeah, this court, who is, oh, you can't see it because I've covered it, but whatever.
I see Freeland logged in. I don't hear.
I'm here, Judy Joyce.
There we go. Okay, got you now. All right, and then Brian Bird or Miss Weaver for Brian Bird. All right, not hearing an answer. Tisa Hall. All right, not seeing that person logged in or hearing an answer. Shauna Hawk. Okay, not hearing an answer, not seeing that person logged in. Derek Dawson. All right, not hearing an answer or seeing that person logged in. All right, now I should have several Oldfields here. So I'm going to start with case 178, Deborah Oldfield.
I'm here.
Okay, thank you. And then respondent, same case, Catherine and Timothy.
Yes, we are here.
Thank you. And Nicole Grant. Oh, you're here in the courtroom. Yes. All right, good morning. Okay, and then Stephen Lovinger. Good morning, sir. Right, Dawn Wilson.
I'm here, Your Honor.
Thank you. And Kimberly Howard. Kimberly Howard. Not seeing that person or hearing any response.
I'm on
Christopher. Here. Oh, you're Kimberly Howard. Okay, thank you. Christopher Harnish.
Are you telling me this guy's name is Paul Wall? His name is Paul Wall? I don't know if I choose to do that. I love it. Also, normally y'all don't always see this part. We just like skip it over and stuff. But like I said, we do it live. We do it dirty. So, but again, this case doesn't come into the case. Paul Wall. Wow. It's interesting. Uh-oh, Nana needs something, guys. Carry on.
Christopher Harnish. Okay. Corey Wimmer.
Yes, sir, I'm here.
I see Corey Wimmer. Okay. And then Nicholas Manel.
I'm here, sir.
Morning. Phil Geigler.
We were not able to get him served.
Okay. All right. I don't see him present either. All right. Thank you. Aaron Dilley. Aaron Dilley. All right. Not seeing or hearing. Kim Jacobs Nicholson. No response. All right. Amanda Wilhelm. Let's see.
I'm here, Your Honor.
Wilhelm is logged in. Thank you. And Christina Smith. Okay, not seeing or hearing any response. All right, and Mr. Frawley, are you here for a client?
Yes, Your Honor. I'm here on the Eden matter. I had received an email that said to be in courtroom 1 that I had been moved. I don't know if that's incorrect.
Eden. We'll run that down for you just a second.
They should be in courtroom 1.
In 1?
Mm-hmm.
Okay. Yeah, you should be in 1. A couple of the protection order cases got moved to other judges because they already had the case. So yeah, you'll be in 1.
Okay, I'll see if I can track that down. Thank you.
Okay, excellent. All right, and then I do want to clear this case first. Carmen Matias Pay.
Well, now I'm gonna have to make a note to fucking check those other courts too. Shit. No wonder this docket felt so light today.
Pedro.
Carmen Matias Pedro, segundo único.
All right, we're not getting any answer. Or with Brett Mackey, which I did not expect because there's been no service. Okay, I'm going to call that case first since we have our interpreter here. And so that'll be 23-115, Carmen Pedro.
Okay.
Mr. Manel, we can reset served on Friday.
That's not the one we're going to watch, guys. I failed Spanish so many times, we can't even do it. Just give me a second. Well, I guess it's at the beginning when he tells him off. Okay.
Served on Friday. Mr. Manel, time.
Okay, thank you.
Okay, welcome. The issue for you, Kayla? I think we're down to the cases we're both. Lovinger, would you turn on your camera and microphone, please? Thank you. This is case 23-179. And I'm going to start by addressing the respondent here because Mr. Lovinger, I see according to the record of service that it was filed with this case today that you were served on Friday. Under the rules, you're allowed more notice than that. So if you're not ready or prepared and need more time, I would give it to you. If you don't feel like you care about the short notice, then we can go ahead with your hearing.
We can go ahead, I think.
Can you hear me?
I can.
All right.
Do you know what you would like to do?
No.
Sorry, it wasn't coming in very clearly there. So I'm sorry, Mr. Levenger, could you repeat what it is you'd like to do?
I could sign the pink pieces of paper. Yeah. This stuff.
Okay, I'm not sure what you mean by that. Would you explain that?
The trespass warnings. Or
Okay.
is that what it's about?
No, it's not about a trespass warning. Ms. Grant has petitioned the court for a anti-harassment order against you. And that's the kind of hearing we're here for today. This doesn't have anything to do with a trespass warning.
Okay.
Did you read the papers that were served on you?
I got one of them. Temporary protection order.
Is that the only thing you were given?
Yeah. And the Zoom link.
Explain?
No, not yet.
Okay.
Okay, so according to this return of service that the court received from an April Stowe, she served on you on Friday a reissuance of a temporary protection order. I don't see that any other documents were served by her. Okay, so let me ask you, Mr. Levenger, did you receive a copy of the petition for an anti-harassment order that Ms. Grant filed with the court?
I don't think so.
You don't think so? I don't see proof that you, so you don't really know what this is about yet, do you?
No.
Okay, so you just came to court because you got this.
I'm dying over here coughing. What the fuck? Why did you come to court then? Dude, how did you show up on the right day? That doesn't make any sense. Guys, go ahead and click that like button, please. YouTube daddy. He collects and likes.
You got this notice served on you by April Stowe?
Yeah.
Okay. Yeah, it's not about a trespass warning issue. This is Ms. Grant asking the court to issue an anti-harassment order that would have, if it was issued, would have some severe potential legal consequences for you. And you have a right to have notice of what that is and a right to be prepared and then be heard on it. And I'm a little bit concerned that you haven't gotten the proper notice and that you're not really prepared to respond to that petition.
Nope.
Yeah, that's kind of what I expected when I saw this return of service. Okay, so just hold on one second here, Mr. Levenger. Ms. Grant, you wanted to say something.
He absolutely knows what this is about. He does. He was told. He trespassed on my property the first time, May 23rd. He then trespassed on my property again on June 15th when he was peering into my windows after being told to not come back to my property. I have documentation from neighbors. He was also served, his two adult brothers came and were in my neighborhood and requested to speak to me. I did exactly what I was supposed to do. I left court for the first time and drove to the Olympia Police Department. I provided the service papers be distributed by Olympia Police Department. I spoke to Angela Johnson in records. Olympia Police went to serve him at his home, and his mother, Linda Levenger, answered the door and said, "Stephen is not here. He's being held in a mental health facility in Centralia." OBD then called me on my phone and said it is my responsibility to.
Whoa, ma'am, you are racing through this story. Tupac thank you so much. Oh, yeah. Hector, welcome. Thank you so much for being here. I've already said it. You guys know where the fridge is. Please help yourselves to a drink. Tell us what you're having to drink tonight or to smoke, whatever you've got. She is coming in hard. This hearing hasn't even started yet. They're asking for a continuance. I'm seeing a lot of he's, you know, trying to get out of it. I don't know. It sounds like he is when we listen to her talk. Good, good. I'm glad to hear you guys are here. I don't know. We're not this. You're hearing what I'm hearing, Kessa. I don't know. We're learning together.
Contact Centralia PD. I then called Centralia PD immediately, and I was told by Centralia PD that the only mental health facility he could be held in was called Maple Lane, that I was responsible for calling the Thurston County Sheriff's Department to have him serve him. I immediately did that. I was told they only had one deputy, but they would attempt. The sheriff went to serve him at the facility, and he was told he was not at that facility. A few days ago, a neighbor came and knocked on my door, a neighbor who provided a statement of what she has witnessed and experienced with Stephen in our neighborhood as well, and said his two adult brothers, David Levenger and Joel Levenger, are at another neighbor's house, and they would like to speak to me. I went across the street. I explained to them what Stephen has done to me on my property multiple times. I provided them with all the documentation that I received of the temporary no contact order. I explained that he had been harassing me. I explained he had court on Monday. I called they said he was not in Maple Valley. He was being held in Cascadia. I called Cascadia that day and asked if they would be willing to serve him. They said no. His adult brothers then called Cascadia and said, we would like you to serve him this paperwork. They said no. I had then called Olympia Police and was told, and they told them that he would be returning back home and he should be served. I have been trying for over 3 weeks with 2 different police departments and a sheriff's office to have him served. My neighbor, Dale Ray, walked over with April Stowe on Friday afternoon when we were told by his adult brother, Dan Levenger, Stephen is now home, you may go serve him. So Dale Ray walked across the street with April Stowe. April Stowe served him, and Dale Ray said, you need to leave him or her alone. Don't go over there. This is about you repeatedly going on her property. Stay away from her. So he fully understands what today is about, and he has had ample warning from his family, from the legal system. You know, I have tried. This is my 3rd time coming to court. I have tried endlessly. So he knows what this is. He knows he has been told repeatedly not to trespass on my property. I have statements from other neighbors who have told him not to trespass on my property, who I share the property
Ms.
with.
Grant, I'm gonna kind of stop you right here.
Okay.
We're kind of getting back to where we started. Okay, much of that I have no doubt is absolutely true, but not all of that is what's important at the moment. What's important at the moment, in order for this to be fair, and when I say fair, I'm using a colloquial term for a legal term called due process. Okay, and I am responsible under the law for making sure that everybody who comes into court and has a hearing has due process.
I understand.
That's what I'm doing. Now, I know that can turn out at times to be frustrating, and at times it can make things take longer than you feel that they should. I completely understand and sympathize with that.
I've also
But,
missed.
Yeah, I'm going to ask you not to interrupt me, okay?
Okay.
Mr. Levenger has a right to know what this is about in the legal sense. In other words, to have properly served on him notice sufficiently in advance so that he can come to court and have a fair hearing. I'm concerned because the record in this case shows that he was served on Friday. That's not enough time. Today's only Monday. And second, the service that was accomplished on him was not complete. Only a portion of what he's entitled to have notice of was served on him. He's not in a position to respond to this in a way that's fair. So as a result of that, I'm going to reset this hearing, give Mr. Levenger an opportunity to be ready to respond to the petition that was filed. As far as I know, hasn't been served on him yet.
So he wasn't home to be served until Friday
date-
afternoon.
The date for that next hearing is going to be on the 24th, Kayla. Okay. And Mr. Levenger, you're not going to get any new notice. Nobody's going to give you another, like, nobody's going to come up and give you a written notice for hearing or, you know, give you a call or an email or anything about this. This is your notice today. Okay, I'm telling you, and then I'm placing in your court file a written version of what I'm telling you, which is that your hearing is going to be on the 24th. And that document, I expect you will look in the court file, you will comply with, and that means your hearing is on the 24th, and the temporary order that the court previously issued for Ms. Grant is still in effect until then.
Okay.
Can you make clear to him that he's not allowed to trespass on my property?
That's part of this order. So yeah, Mr. Levenger, you absolutely have to comply with the conditions of the order because you can be arrested if you don't.
Yes.
I just want to say that the 24th will be my 4th time attending court, and my son is missing vital medical appointments in order to make these. Because he has appointments Monday at 9 a.m. This is the 4th time he's having to miss a vital medical appointment because I'm a single parent who doesn't have anybody else to take him, so I can come back to the court to deal with this yet again. So this is seriously impeding my son's health in order to do this. And it's not as though we waited till the last minute to serve him Friday. He was not home. I made so many efforts to have him served.
I don't doubt that,
It
Ms.
took
Grant.
3 police departments
I don't doubt
and a
that.
sheriff's office.
I
And
don't.
nobody would help me.
I know that this isn't easy to do.
No, it's not.
And
It's
sometimes
terrifying. I live in
sometimes
town
it takes.
since May 23rd of this man.
All right, well, Ms. Grant, the hearing date's going to be on the 24th. You've got notice of it too. Everybody knows now, everybody has sufficient knowledge in advance of the hearing and what it's about. So we'll conduct that hearing and make a decision on the 24th. All right, any questions, Mr. Levenger?
Where do I find this stuff?
All right, we'll see you back here on the 24th.
Same room
Same room
at 9 a.m. Yep. Okay.
at 9 a.m.
Okay.
Wow. What do you think is going to happen then? Now we skip ahead.
Ask you to both.
This becomes very perplexing to me. You'll find out why. Sponsored by Xanax, Dave. I wish. That'd be great. Let's just see where this goes. I don't understand. Their last names are the same, but they're not related. It's crazy. You guys know how it is down in Thurston County. Stuff is crazy.
Turn on your cameras and microphones. All right, we're here on 23-178. That's Deborah's petition for anti-harassment order against Catherine and Timothy. And then I continued from Friday an ex parte request for an order from Catherine and Timothy for an order against Deborah, and that's case number 23-202, and that will also be heard today. Okay, so for all of you, since everybody shares a last name, my intention would be to refer to you all by first names so that the record is clear when I refer to you or when you refer to each other. Does anybody have any problem with that level of informality in this case?
No, Your Honor.
Okay, I think that'll just be clearer and easier for everybody. Okay. Now in this matter, I'm referring primarily to case 178 here, since that's the case that was on for a full hearing. The court had heard the matter ex parte, had declined to issue a temporary order, but instead set the case for a hearing to determine whether to issue an order at all. And that's primarily what I'm going to decide today. Under the case number 202, I will also decide whether any kind of order will be issued in the other direction. Okay. So what I'm going to do here, just like the other cases you may have heard, is I'm going to swear everybody in, and I'll hear from the petitioner first, in this case, Deborah, and then I'll hear from the respondents and make a decision. Again, keep in mind that the material that you've filed in this case has been reviewed by the court and is already part of the record. Okay, can I have everybody raise your right hands, please? And do each of you swear that the testimony that you give in this matter, in these matters, will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, very well. So starting then with Deborah.
Thank you, Your Honor. So you have all the information that I submitted to the court. All the arguments and finger pointing are merely context. The bottom line of the matter is that these people have no legal right to me or my children. I found Tim's text messages in April to be annoying and asked him in writing 5 times to stop. Before he finally did, I attempted to pause communication with the Oldfields until I could downregulate my nervous system after suffering an interpersonal trauma and give the communication the calm attention it deserved. My request for peace was met with repeated harassment with
Oh, whoa, wow. We are West Coast deep here. Lucky for you guys, I live in Hippieville, Canada, so I can translate that for you. Look at her husband. He's just looking at her like, oh my God, this is the woman that I married. This is the woman that I married.
stop. Before he finally did, I attempted to pause communication with the Oldfields until I could downregulate my nervous system after
I attempted to shut them up while I was freaking the fuck out, but they wouldn't stop.
after suffering an interpersonal trauma and give the communication the calm attention it deserved.
I knew I was being out of line and that I probably should respond differently, but I was fighting with somebody else and I couldn't stop.
My request for peace was met with repeated harassment with escalation. I had no contact with the Oldfields between the text messages in April with Tim and the vile letter from Catherine on my birthday. I'm afraid my kids have instructions to call 911 if the Oldfields show up at our house.
All right, is there anything else you wanted to say about the matter?
There's nothing further, Your Honor.
Okay. Let me hear from Catherine and Timothy.
I just, we've tried to stay away and give them respectful distance for quite a while. When they do contact me and make a statement, I usually ask for clarification. So I guess what Deborah's talking about is who gets the last word. And, it's like, okay, well, that's done. There's going to be no clarification, and that's okay. I just hope they get the help they need and that things calm down for both sides of the mountains. We live on both sides of the Cascade.
Can you remind me, just because it's escaping me right now, can you remind me where you reside?
Chelan, Lake Chelan, Washington.
That's right. Okay.
North Central.
Okay. Yeah, when you referenced both sides of the mountains, then I realized that I had forgotten where your residence was. Okay, thank you. All right, and then Catherine, did you want to say anything? You were kind of anxious to address me on Friday when you came into court.
Your Honor, I mean, as clearly has been shown through the documentation, the letter that I sent Shane and Deb, 90% of it were Deb's own words. And we were saying that's enough of the harassing, that's enough of the bullying. If you want to have an adult relationship, we're willing to do that, but this has just got to stop.
What kind of adult relationship were they trying to have? Because they're not family. That's the weirdest part about this. Seriously, how odd. She's slinging it back though. She's like, we used all your words. I am not model material. Yeah, I know that. I'm good with that. Your nightmare. But, you know, last night you left a comment on one of my videos saying how pretty I was. So are you just like bipolar with that? Or what? Anyways, no, we don't get rid of the trolls. You guys can block them. I don't block them. I enjoy it.
It's interesting that Deb finds it so vile when 90% of it was her own words, as I documented in the declaration that was sent to you with the transcript of everything that she's been sending and doing and saying. Deb noted in her documents that I repeatedly refused to respond to her, honoring Shane's request that we not contact his family. She also noted in there that we haven't been at their house for years. At this point, you know, we have talked, and Tim has been asked that if Shane or Deb shows up here to lock himself in the house and call 911, given the very real threats that actually happened. This is heartbreaking on so many levels, heartbreaking that this is what this has come to.
Right.
Jan,
And
if I may add, I'm not privy to
there was
Catherine submitted to the court.
Since there was a petition by Catherine, I wanted to give you a chance to sort of respond to that.
They received those documents on Saturday, shows they were delivered Saturday.
Okay. Yeah, I know, short timeline, but if there's any response you want to give to that, you certainly can.
Your Honor, we received no documentation.
You haven't yet?
No, not at all.
Okay. All right. I did review those on Friday because, as I said, they came to the court as an ex parte petition, meaning one party was before the court. And when I received the response, or I should say, when I received the petition, I took it more as a response to Deborah's petition. In fact, I think, Catherine, you said that this was your response. And my impression was maybe, especially since the case number for Deborah's petition was put on the declarations, that you really were more responding to her petition than you were really initiating your own, although technically what you did is you initiated your own petition. It makes the matter kind of a little bit more confusing, but at the same time, if I consider it in the context of the initial case that was filed by Deborah and consider this as more your response, then it all sort of fits together a little bit better. And maybe that's just how my mind works in approaching this, but okay. You all do have a complicated family dynamic. I will confess, it took me a couple of times reading to sort of sort out the players and who's who. But I mean, I think I have a basic understanding of that. And unfortunately, the family dynamic that you do have is not probably satisfying to anybody, and not healthy either. So I think anyone reading this material and listening to you folks would clearly come to the conclusion that you really shouldn't have any contact, and you probably really should just stay away from each other and not get into each other's orbits at all. And that's one way to look at things, and maybe that's a productive way to look at things. But that isn't really what you've asked me to do. What you really asked me to do is issue legal orders against each other that have, they have consequences. Those orders not only prevent people who are subject to them from contacting each other in various ways and other sorts of restrictions, but they carry criminal penalties for when the provisions of the orders are violated. So this, they're serious. They're quite serious, and they can pretty substantially restrict what people can do in their lives. And that's why the law is written the way it is in terms of protections for burdens of proof that have to be shown in order for the court to issue an order, and then restrictions on the kinds of relief that the court can give you. So recognizing that, I take note that I believe I don't want to misidentify the judge who originally heard this, but Judge Buckley, he heard this on June 26th, and he did not grant a temporary order, and that can be
June 26th. Kessa, as you say that though, I'm feeling so like we've seen them. They were talking about horses and like ATV dust, but it might have just been over with Mikey, Credence and Mikey. Guys, if you're just getting here, this is a anti-harassment order hearing, and the judge is about to, it's not them, Mikey. Okay. Trailer view, very similar. Not the easement either, Hector. We'll have to look back. Everything in my stuff is dated. So June 26th in front of Judge Buckley. We'll have to look back and see. But it was denied at that point. Is that what they said? That's what he said, I think. Anyways, let's continue.
For a couple of reasons. One, maybe he didn't find that there was an emergency situation, but and the other may be that he wasn't convinced, at least to a preponderance of the evidence standard, that there was legal harassment happening to justify giving that kind of relief. And I have maintained that concern ever since your case was assigned to me. So having gone through it in preparation for today's hearing, and then having gone through it again because Catherine brought in additional evidence, and hearing from you folks today, my position's really about the same. I don't think that I'm satisfied by a preponderance of the evidence that there's legal harassment going on. I think it's definitely upsetting when there's contact. That's for other kinds of reasons, not because of harassment as the law defines that. So what that means is that I don't believe that there's sufficient or sufficiently strong evidence to issue an anti-harassment here. I should say under case 178 against Catherine and Timothy. I don't think that's been shown. And then since I did reserve judgment on the petition that Catherine filed on Friday under case 202, I'm going to make that judgment now. And really the same concerns are there. And the result is the same, and that is that I don't see the evidence that satisfies me by a preponderance of the evidence, the greater weight of the evidence, that there is legal harassment going on that would justify the court issuing an order against Deborah either. So that's the sort of sum total, that is the result, and that is the reasoning that the court's using in order to deny both petitions. I know that doesn't solve any of your problems. I know that doesn't make your family dynamic more functional or satisfying, but the law has limits, and the law has limits on what the court can do. And I think I have to honor those, even though for you, I think collectively you, emotionally, this is difficult stuff. I can tell by talking to you. I can tell by reading your materials. So that is the judgment of the court. That's the ruling of the court. That may bring questions to mind. And if you have questions, you can ask them. But I do want to tell you that one, the decision is made, and two, I may not be able to answer all your questions. I may just be able to give you guidance on what this means. All right. And I see, Deborah, you kind of had your hand up there for a bit. Did you have a question?
I do, and I think my husband does as well. So Timothy went on to harass again through my mother-in-law on or about either the 3rd or the 4th of July, nasty statements. So I just want to, I know your decision is made. I disagree wholeheartedly with it. I don't think that the harassment is going to stop.
I would also like to add, Your Honor, that you keep throwing the word family out there.
They're not family.
We just share the same last name.
Yeah, I got that. I understood. I'm using family in kind of the modern vision. People sort of make their own families these days. And I know you may not consider yourselves family. I just use that term sort of loosely. All right. So folks, as I said, that's the decision of the court. In each case, that's going to bring the matter to an end. There won't be any further hearings scheduled unless something changes, and there are no anti-harassment orders issued in either direction.
Thank you. Thank you, Your Honor.
Thank you.
Thank you, all of you.
I'm very perplexed by that hearing. I don't understand. I mean, if they're not related, why would you colloquially, why would you use the term family when they're not family? That seems so odd to me. If we think back, because her initial, what would we call it? Speech was like, it was a very odd presentation. Let's just say that. It was very odd. The fact that they have the same last name, very odd opening. Thank you, MB. Thank you so much, MB. Yeah, I don't know. That one seems very odd to me that it was dismissed. I mean, this judge we've heard him hear crazy things before. No, like apparently they're not related. The judge considers them family. I really don't. I don't know, to be honest with you. All I've seen is what was there. Although later tonight I will, with 15% probability, go back and look at the previous day that they were speaking of, June 26th. That number goes way higher if Jonathan, if you go ahead and timestamp me that in Discord. Judge thought they were related. I believe that, Mikey, 100%. I totally believe that. So, guys, that is what I have for you this evening. We have had quite a great night. If you were late arriving, that's okay. Just make sure that you've hit the like button. And if you want some more, I posted a video just before this live from Judge Webster. It was a great one. Some of you have seen it, some of you haven't. Definitely go check it out. Credence and Mikey are here, almost out of YouTube jail on Wednesday, but I have posted their alternate channels on a community post. I should have done that sooner. Somebody remind me of that next time, to do it right on the first day that happens, okay? Thank you guys so much for being here. I really appreciate all of you. I'm going to go create some more court for us to watch and enjoy. And I hope that you guys have a wonderful evening. So remember that I love you and I'm proud of you. And I will talk to you soon. All right. Bye. And yes, it is next time. I love you guys. Have a great night.